Good evening. This is week 4, Laws 11057 Introduction to Law, and tonight we'll be talking about critical thinking. I do want to tailor this course to be as practical in its application as possible. And at this stage, I want to start introducing some legal concepts that hopefully will provide you a head start in terms of the work that you need to do in other subjects into the future. Tonight, introduction to criminal law in a very basic sense. I want you to be aware of two things. The first is the right that a defendant has or an accused has to silence, and we talked about that last week. The accused simply has an obligation, generally speaking, to advise the officer in question of the name, the address, the date of birth of that person, and nothing more. So if you find yourself in your first week of practice as a lawyer being asked to give some advice to someone over the phone in relation to some issues that have arisen, then perhaps you can keep that in mind. Gordon, I'll just get you to mute your microphone. Done. It's done. Thank you. And hello, Robin has joined us, Tony's joined us, Kirthy has joined us as well. That's great. All right, so firstly, have that right to silence, and that's generally the advice that you should give to someone. The next is if you are called upon in your first week as a lawyer to go down to the watch house and represent someone on a bail application, here are a few of the basics. The first is that you'll probably receive the call from the watch house keeper, but it may be that you receive the call from the investigating officer. If it's the watch house keeper, odds are that he or she will probably know not too much about it. So other than perhaps asking for the name of the client and perhaps the charge and asking if it's okay to go down to the watch house now, you probably won't need to speak to the watch house keeper for very much more than that. If, however, you're speaking to the arresting officer, you probably want to know a few more things, and that is the client under arrest? Is the client likely to be placed under arrest? If so, is that an arrest for questioning only or an arrest warrant? If the client is being charged and arrested, then the next question you want to know is, has the client said anything already and that you wish to give the client some advice? And then indicate that if the client is charged, or ask the question, if the client is being charged, do they intend to contest bail? And if so, would they be willing to consider any conditions? You then speak to the client, and generally speaking, you advise the client not to make any statement. It would only be if you're feeling particularly brave that you would advise your client to do anything other than that. Indicate to the client that you've spoken to the police and that ask if it's okay for you to then go back to the police officer and say that the instructions are that you're not going to make a statement. Also, that you've spoken to the police officer and the officer's attitude is that they're going to arrest you and they're going to object to bail, or whatever the case may be. If there is an objection to bail, let the client know that you'll be in attendance for the bail hearing. If there's not necessarily going to be an objection to bail, you may be able to negotiate some things with the arresting officer, and that is perhaps that the client can be released on his or her own undertaking, that is no conditions, or if there are going to be some conditions, try to make sure that they're reasonable conditions and not over the top. An example of an over the top condition might be that your client is subject to a 24-hour, 7-day-a-week curfew, can't leave the house. That might be regarded as too onerous. And it might be that you can negotiate on the spot to have that reduced down to reporting at the police station, let's say 3 times a week. But better still, no conditions at all. And bear in mind, of course, that if the client is released on bail, all of this needs to be revisited once the matter comes before a magistrate at first instance. So it is, in a sense, just a temporary matter. If you do appear at a bail hearing and it's contested, the basic thing that the magistrate will want to know is this person a flight risk? Are they a risk of reoffending? And what do the police have to support that? The preliminary question to determine is, who has the onus of proof in the bail hearing? If you have a client, for example, who's charged with a matter and they're not on bail already, and there's no allegation that a weapon was involved, for example, then generally speaking, the presumption is that the person will get bail and the police have to prove otherwise. That can be reversed, and you need to look at Section 16 of the Bail Act to see the reasons and circumstances when it will be reversed. But generally speaking, if your client is charged with an indictable offence while already on bail for an indictable offence, then your client is in a show cause situation. Likewise, if there is an allegation that a weapon was used, then your client is in a show cause situation. And what that means is that now the onus is reversed and you will be denied bail unless you can show cause why that should not happen as the defendant. All right, that's all I propose to talk about in relation to dealing with the police at first instance and dealing with the watch house keeper and making the preliminary bail application in front of a magistrate. Oh, just one other thing. Some offences, magistrate has no power to issue bail. So if your client is charged with murder, you'll have to go to the Supreme Court. The magistrate won't be able to deal with it. I know that's very quick, and it's meant to be just a quick introduction. It's all accessible, of course, but only to the degree that I expect you to know it in your first foray into introduction to law. Does anyone have any questions about bail or that preliminary advice that you need to give? Nothing on the chat line? When they ask to sign a bail undertaking, what are they signing to say? The bail undertaking is essentially a promise to turn up at court when required to do so. And it's an offence to breach a bail undertaking. It's a criminal offence to breach a bail undertaking. So it's an A4 piece of paper, and it provides the details of the charge, and it's a promise that I undertake, this is the defendant, to turn up at court when required to do so, and it's on this certain day at this time. So that's what a bail undertaking is. Now, there was just one other thing I was going to mention to you, and it slipped my mind for the moment. So if anyone had a question, that would be good. It would buy me time. No
John,
question?
I'll throw one at you then.
Yes, Jason?
The bail application, the undertaking, I guess, is essentially a contract. Does that then come into contract law? Is the person of sound mind at the time? Those sorts of things.
Sure. No, it's not really. It might look like a contract, but it's not a contract. So it wouldn't have any civil application at all, purely criminal application. And as indicated, it's essentially it's solemn to the degree that if you don't comply, you can be then charged, and probably would be charged, with a new criminal offence. The other thing I wanted to mention while I remember, I hope that answers your question, Jason, was be aware that any conversation that you or your client has with police is likely to be recorded. Whether they announce it or not, it's likely to be recorded. So if, for example, you have a call from a client saying the police are here, they've issued a search warrant, what do I do? You say, sit tight, I'll be there, don't make any statements without me telling you to do so, and don't interfere with the process. And just say everything is being recorded. And likewise, they'll record what you're saying too. Okay, thanks, Jason. Anyone else? Now, of course, I'm making all these statements about, yes, we'll be down at the house, yes, we'll be down at the watch house, we'll do all these things. But unless you're the principal of the firm, you want to check with your principal if you're happy to be, if he or she is happy for you to be off running off doing these things. Okay. The next thing I want to talk about is thinking skills and the IRAC method. I say IRAC because that's the one that I tend to use. Issue, rule, application, and conclusion. Everyone's done your reading, so I assume that you understand what I'm talking about there. If you want, you can add the conclusion at the start and then repeat it at the end. We do that a lot in advocacy. We might say, when we stand up to make a submission, we might announce to the court what it is that we're leading to as our final conclusion, or what it is that we seek at the end of the day, and then go through that process of IRAC on your feet, as it were, going back to the conclusion at the end. So IRAC or SIRAC, there are a few other different versions, and really none of them are necessarily any better than another one, so you take your pick. I do like MIRAT, if that's the right way to pronounce it, because I think identifying the material facts from the outset is really quite important. And we saw that in the discussion involving Catherine. And thank you all for your contribution in terms of that discussion. And when I talk about Catherine, I'm talking about the avocado incident at the local supermarket. My take on that is this. What's relevant, what's material, is that Catherine was shopping. She was shopping at the local supermarket. That she selected an avocado and squeezed it gently. I think that's the second thing. And put it in her basket. You can probably put those things in the one material fact. So the number one, she was shopping. Number two, she picked up an avocado, squeezed it, and put it in the basket. That's number two. Number three, she returned the avocado to the display. And number four, she's stopped by the manager. I think they're the material facts. Does anyone disagree and wish to argue that anything else is material, or that anything that I believe is material is not material? Okay. The reason that we need to, in many ways, determine what is material from the outset is so we can then say, from that, here are the legal issues, here are the legal rules, here is how we apply it, and here is our conclusion. So even though I'm saying IRAC, perhaps we add the M in front as well to determine the material facts. So what I've suggested is really a hybrid of the ones that are in the text. As I said, there's no hard and fast rule on this. You see it as which is comfortable for you. But it's a great technique to keep in mind, because if you really get writer's block in a legal assignment or a legal letter or an opinion when you're in practice, just follow that formula and it'll get you going. Just as an aside, in terms of the legal issues for Catherine and the local supermarket, I think the issue is to do with contract, and there's a distinction between a contract and an invitation to treat. You'll learn all about that in contract law. We'll talk about that later as well. But in short, I think she was perfectly entitled to put the avocado back, having changed her mind. She hadn't left the store. She hadn't, by her actions, made an offer to purchase the avocado, although that may be an argument on behalf of the store that by touching it she did, but I doubt that would succeed. So I think it's a contract issue, and I think that Catherine is perfectly entitled and the store owner is wrong. Again, anyone disagree with that summation? All right. I just want to talk to you about Introduction to Legal Research. For those of you who undertook the task that I gave of finding the Australian consumer law and finding the criminal code, congratulations, particularly if you found it. If you did, you get some insight into legal research skills. The reason I chose those is they're really important. You just want to know, in practice, you want to know how to get to the Australian consumer law, and you want to know how to get to the criminal code. Sometimes all you really need to do is know how to get to some of the really important places, or at least know how to get to some of the others. And I would suggest to you, without wanting to be unkind, that a lot of, well, let's say some practitioners would actually struggle to find the Australian consumer law and might even struggle to find, not the Queensland Criminal Code, but they might struggle to find the Commonwealth Criminal Code. I hope I'm not being unkind to my colleagues in that regard. Now, Robin says, going back, contract law says she intends to buy it only when she takes it to the counter. Yes, I agree with that, Robin. That's when the offer is made. Tony, is that the 1899 Criminal Code? Yes, it's the Criminal Code 1899, which is actually a schedule to the Criminal Code Act. You probably saw that. And likewise with the Commonwealth Criminal Code, it's a schedule to the Commonwealth Criminal Code Act as well. Any further questions? All right. So I will try to encourage you to do that legal research as we go. And of course, there'll be more time devoted to that as we go through the course. Let's move on to reasoning, deductive reasoning. All x's are y. This z is an x, therefore this z is a y. Let's put that in an example. All dogs, x, are mammals. That's y. This animal, z, is a dog, x. Therefore, this animal, z, is a mammal, y. You've just got to go through that for yourself a bit. Has anyone had any difficulty in determining what we mean by deductive reasoning? That simple example that I gave? No questions? All right. Inductive reasoning, simply prediction based on past experience. The example in the book, you've ordered cheap coffee 3 times in a row. You've not enjoyed it any time. You order the same cheap coffee a 4th time. Well, one might, through inductive reasoning, predict that you won't like it again. No questions there? Faulty reasoning, sweeping generalizations. Now, if the main premise of your reasoning is overstated, then the conclusions will be invalid. There's some excellent examples there in the text. All politicians are corrupt. It's an overstatement. This person is a politician, therefore this person is corrupt. Well, the conclusions could never stand once you've had such a sweeping generalization in the first instance. Hasty generalizations made in circumstances where there's simply not enough evidence to support what is being said. Hasty generalizations look a little like inductive reasoning, but it's different. So inductive reasoning is, I don't like cheap coffee, I don't like cheap coffee, I don't like cheap coffee, therefore I'll have this cheap coffee, I probably won't like it. You see, it's really focused and it's narrow, whereas a hasty generalization is much broader. There's just not enough evidence to support it. I met 4 Chinese students. They were all extremely intelligent. Therefore, all Chinese students are extremely intelligent. Well, that's faulty reasoning. It's hasty generalization. You can't make that type of generalization based on a sample of 4. And you see how it's different to inductive reasoning, which is very narrow in its focus. Attacking the person. Hitler was vegetarian. He was a bad person, therefore vegetarianism is wrong. Just because he was a bad person and happened to have, as we all do, a trait or a characteristic, that does not necessarily mean the trait or the characteristic is bad or wrong. Any questions? And I'm about halfway through marking the assignments. Excellent so far. Really happy with the work. So thank you collectively. Appeal to authority. It's okay to question what is said, even though the author of the authority is someone in a position of power or trust, perhaps. And no, you don't need to remember Latin names, only if you want to show off. So, let's see. I don't mean to be overly political or religious here, but can I just say that it's perfectly possible for the head of state, politician, to be wrong. It's perfectly possible for a person in high office in a religious capacity to be wrong. It's possible that scientists are wrong. And if we look at history, there are many examples of those scenarios over many years. I guess 600 years ago, scientists believed that the Earth was flat, but they were wrong, of course. So just because a person in authority with credentials makes a statement, that doesn't necessarily mean it's wrong. So it's okay to question what's said. Now, if we have a matter, a constitutional matter, which goes to the High Court, and 4 of the judges go one way, 3 go the other way, does that mean that it's wrong for those 3 who dissented to have questioned the decision of the other 4? Of course not. So there we have a situation where 4 High Court judges are being questioned by their colleagues in terms of their decision. Now, that said, of course, if it becomes a High Court case, it is binding on us. Now, there was a question there, sorry.
Yeah, John, sorry, it's Libby.
Yes, Libby.
That makes sense. I just wanted to clarify a perspective with you then. Working in healthcare and being employed by our government, I'm quite aware that the federal government passed some legislation to the effect that if a government employee is seen to be speaking in a negative manner regarding government decisions and policy, they can lose their job. So I'm gathering that this concept is only relevant unless there's legislation in place to stop you from disagreeing with the authority.
Yes, there's always whistleblowers legislation which might protect you, but yes, there are contractual issues, there are employment issues that come into play as well. So at this stage, I'll restrict my comments to perhaps more general comments, and that is in terms of the appealing to the authority, appeal to authority. In a similar vein, we have appeal to majority. Just because most people think one way does not necessarily make it so. And Robin has been posing some very interesting and difficult questions on UCRU, and I thank you very much for that, Robin. Straw man argument is misrepresenting or exaggerating the opponent's position on something and then distorting the argument. So just because the example they give in the book is very good in that regard. Yeah, in terms of what a protagonist in favour of legalisation or decriminalisation of marijuana makes a statement and then is attacked illogically in terms of the ramifications of doing that. So that's the example in the book. Irrational correlation and causation. I love this example. So during the last 100 years, there have been less pirates. But in that same 100 years, we've had an increase in global warming. Therefore, global warming is caused by the lack of pirates. So clearly an irrational correlation, no causation there at all. So just be aware of those issues in terms of reasoning, faulty reasoning. You probably won't have those in practice. I mean, it's not as though a client will walk in and ask you for some legal advice in relation to the issue of faulty reasoning, but it's more something to be aware of as you process through your course and in practice following that. All right, any questions on reasoning, faulty reasoning at all? Any comments apart from good on you, Robin? Okay. Let's move on to critical thinking. When you're...
Oh, can I ask a question?
Yes, Tony?
Can the government ever overrule the High Court?
Yes, all the time. So the High Court, and it gets into a cycle. So you have a situation where, let's say, the government, federal government, introduces some legislation in relation to some environmental law. That is then challenged. The High Court rules against it. Then, to the degree that it's constitutionally possible for the High Court for the federal government to do so, they simply pass
Another act.
legislation to overturn the decision of the High Court. Yes, I hope that makes sense. Thanks, Tony.
Yeah.
All right, critical thinking. So when you're thinking about law, you need to follow some basic tests. You need to try to speak and act reasonably. You need to back that up. It needs to have some validity behind it, and you need to be objective. And you need to consider that what you do is to some degree fair and just. Fairness and equity comes into it. So that's judgment. That's you being judged as a critical thinker. There's some of the issues that are relevant. Thinking skills. Yes. No, I agree with you, Gordon and Jason. Yep. In terms of the bikie laws, that is. Right, thinking skills, page 290. There's a list there. You need to interpret, analyse, evaluate, infer, explain, and then there's the topic of self-regulation. Now, why is that relevant? Because part of the threshold learning outcomes desired of you in completing this LLB course will be your ability to progressively do that, to interpret, to analyse, to evaluate, to infer, to explain. And there'll be different synonyms which are thrown to you in that regard as well. And as you progress further through the course, you'll make the transition from being able to identify and know to being able to infer and analyse and interpret. So the word that's asked of you in an exam will change. So just be aware of that, the different tests in terms of your ability to critically think and analyse. Any questions though? All right, so the thinking skills, which are referred to on page 90 and expanded upon on page 290 and expanded on in 291, they're the basic skills, but the question is, can you put those skills into action? And if we look at page 296, we see some of the things that you need to do to have, the attributes that you need to have to be an effective legal practitioner. You won't necessarily need all of them, but this is what you need to aspire towards. So you've got the thinking skills, you understand, you're able to analyse, you're able to, you're able to draw inferences, but you then need to put it into practice, put it into action. And part of what you need to do is you need to be inquisitive. you certainly need to be alert as a legal practitioner. There has to be a degree of self-confidence, which is not arrogant. You need to be open-minded, flexible, fair-minded. You have to have some self-honesty, prudence, diligence, and persistence. So I'd really ask you to look at that list carefully, maybe even print it out. Have it somewhere that will remind you often as you progress through the course and you progress to be a lawyer, to say, these are things to be aware of if I'm going to be an effective legal practitioner. Any questions about that? So what was that? Was there a question there, Gordon, that you wanted to ask? Ah, yes. Yes, the question in an exam will cue you in, and you'll see the exam might start by saying, analyse the anti-bikie legislation and critically comment or critique it. So that's more than just saying, here's what it is and know it. You've got to do more, and you've got to analyse it and draw inferences from it. Whereas if the question is simply explain, then you can get away with just saying, look, here's the legislation and here's how it works in practice. You're not asked to go beyond that. I hope that answers the question. That's all I propose to talk to you about in relation to Chapter 8. You can read for yourself the issues about creative thinking, which tail out the chapter. Any questions before I move on to Chapter 11? How would I critique, says Melissa. Well, let's say the Property Law Act provides that in the event that a contract for the sale of residential, so we'll assume a situation, a factual scenario. We have a contract for the purchase of residential real estate, a house. The price is $500,000. The deposit is $51,000. Now, you'll become aware that because the deposit is now more than 10%, that contract is an instalment contract. Section 74, I think, of the Property Law Act says that. So I now know that that's the case. But let me critique that. Let me analyse that. What that then means is that there are consequences that flow both to the buyer and the seller as a result. If you're a seller, you need to be aware that time is no longer of the essence, and in the event of a default by the buyer on the due date for settlement, you then need to provide a notice to complete, which calls upon the buyer to settle on a certain date. In other words, you need to re-establish that time is of the essence. For a buyer, what it means is that the strict rule that the buyer must complete on the day of settlement no longer applies, and it provides them with a greater opportunity to defer settlement. If we further critique that situation, as opposed to simply saying that it becomes an instalment contract, we say another consequence of that is that the buyer can only lose up to 10% of the purchase price, which is $50,000, and cannot forfeit $51,000. So there's another issue there as well. So critiquing means establishing quickly that you know what the law is and you're able to refer to what the law says, but you then need to go further and talk about the consequences, the ramifications, perhaps the probity of having that law in the first place. That's what I mean by critique and analyse. Sorry, that's a pretty tough example off the top of my head, but I hope it gives you some idea of what I mean. Any questions flowing from what I've just discussed there? Thanks, Melissa. That was a little involved. That was a kind of second or third year discussion we had then. Libby, I thought Chapter 11 was allocated to week 7, according to Moodle. My apologies if I've got it wrong. Just having a look at Moodle now. I'd made a note to myself that I would deal with chapters 8 and 11 today, and maybe that's just me making it up. What's on the chat?
John, it's Robin.
Yes, Robin.
The lecture on Moodle said that it was chapters 8 and 11, but the notes only said chapter 8.
Oh, okay. Thank you very much. Yes, I can see. Yes, on Moodle on the front page it says 8 and 11. All right. Well, what we might do, thank you. I might continue with chapter 11 anyway. I don't want to talk too much about it in any event. And really, I'm just going to talk about judicial activism. And that'll do us for tonight. Pages 384 and 386, or through to 386, deal with judicial activism. There's a chance that this might be on the exam because, to my mind, it does relate to the separation of powers. Judicial activism is where a judge reforms the law and essentially creates something that didn't exist beforehand. We all know, of course, that common law is made by judges and that common law is part of our law. We know that the doctrine of precedent means that certain courts have the power to essentially bind other courts that are lower in the food chain, so to speak. So what's the difference between judicial activism and ordinary everyday precedent law and common law? I guess it's a question of the degree to which the law is reformed. In the text, the commentators say that if a law is unjust or obsolete or defective and the judges overturn that completely, then that's an instance of judicial activism. Of course, the famous example is that of Mabo. In that case, the High Court made the dramatic change by saying that native title did exist, and what we thought was the law since 1788 through to 1992 was in fact wrong, and that Australia was not settled as had previously thought was the case. So in that case, there was no legislation that introduced the concept of native title. It came about as a result of judges in the High Court saying it exists. Now, it just so happened, going back to a comment that you made, Tony, that the federal parliament chose not to overturn what was decided in Mabo, but rather embrace it and regulate it through legislation, which of course was the Native Title Act of 1993. But it could have gone the other way. The Native Title Act of 1993 might have been headed the Native Title Abolition of Interest Act 1993, effectively to overturn the decision of the High Court in the Mabo case. But that's not the way they went. They went the other way and embraced it. Yes, Tony, and it was, I think, to change past injustice was the rationale behind it. But you can see that that's not, the Mabo decision was not really part of the common law in the sense that we use common law as being judge-made law. This was judicial activism. This was creating something that never existed before, and something was created out of a vacuum. Read about the critics of judicial activism who say it has retrospective effect, that it's something which is being created by second-rate lawmakers. Politicians are first-rate lawmakers, judges are second-rate lawmakers, and that it contravenes the whole concept of separation of powers. We can't have a situation where judiciary is required to interpret law and suddenly they're making the law in the way in which the judicial activism creates law out of a vacuum. All right, now we've got a few questions, I think. Was that through statutory interpretation of the Constitution? Would you mind expanding on that, Gordon? If I can put you on the spot. All right. yes, the Commonwealth had the constitutional power to introduce the Native Title Act, which they did, and that confirmed the law that was made through the High Court in Mabo. I'm nearly finished. Well, I'm halfway through marking your exams. Assessment number 1. Excellent work so far on average. What I propose to do is this. Sorry, Gordon. The Constitution says racial discrimination is not allowed. I'll correct you on that a little bit. The Constitution allows for the federal government to make laws in relation to issues such as racial discrimination, but it's the Racial Discrimination Act of 1975 that first introduced the concept of outlawing discrimination based on race. I may stand to be corrected on that, but that's the one that stands out as the important piece of legislation that dealt with racial discrimination. And it was created as a result of the Commonwealth having power under the Constitution to do so. I hope that clarifies it, Gordon. And please let me know if you disagree with what I've said. All right, so coming back to the exam, what I propose, or the assignment, what I propose to do is this. For each one of you, I have tailored individual comments. I won't resend your paper back to you with my comments on the paper, but you'll have my comments about your paper. And then I'm going to have quite a lot of information in relation to generic comments for all of you to take on board. And once I've posted those generic comments in one of these Zoom sessions, I propose to elaborate on that and ask for your further questions. And I'm sure that UCrew and Moodle to a lesser degree will have lots of questions, comments and discussions about what I say in relation to it. So I hope that's acceptable to everyone. Okay. All right, so any final questions or comments before we adjourn tonight's proceedings? And if I'm a little slow this week in responding to questions and comments on Moodle and UCrew, please excuse me because I'm knee-deep in assignment marking. I'm sure you understand. All right, well, I'll stop the recording now.